Welcome to our video on trade secrets and industrial designs. In the world of business, protecting your ideas and creations is crucial. Intellectual property, or IP, refers to the legal rights that result from intellectual activity in the industrial, scientific, literary, and artistic fields. Today we'll focus on two important types: trade secrets and industrial designs. Understanding these can help businesses maintain a competitive edge and safeguard their innovation. Let's start by exploring what makes these forms of IP unique and why they matter in today's fast-paced market. Trade secrets are a form of intellectual property that protect confidential business information. This information gives a company a competitive advantage and is not generally known to the public. Examples include formulas, practices, processes, designs, instruments, or compilations of information. The key is that the information must be secret and valuable because of its secrecy. Companies go to great lengths to keep trade secrets safe, using measures like non-disclosure agreements and restricted access. Let's look at how trade secrets work in practice. Some of the world's most famous products are protected by trade secrets. For instance, the recipe for Coca-Cola is one of the best-kept secrets in the business world. Similarly, Google's search algorithm is a closely guarded formula that gives the company its edge. These examples show how trade secrets can be more valuable than patents, as long as the information remains confidential. Companies invest heavily in security to prevent leaks and unauthorized access. Like patents or copyrights, trade secrets are not registered with the government. Instead, protection relies on the company's efforts to keep the information confidential. This can include physical security, digital safeguards, and legal agreements with employees and partners. If a trade secret is leaked or stolen, the company can take legal action against the responsible parties. However, once a secret is out, it's hard to regain its value, making prevention the top priority. Misappropriation occurs when someone acquires, discloses, or uses a trade secret without permission. This can happen through theft, bribery, or even accidental leaks. The law provides remedies for companies whose secrets are stolen, including damages and injunctions to stop further use. However, proving misappropriation can be challenging, especially if the information was not adequately protected. That's why companies must be proactive in securing their valuable data. Employees play a crucial role in maintaining trade secrets. Companies often require staff to sign confidentiality agreements and undergo training on handling sensitive information. When employees leave, they may be reminded of their ongoing duty not to disclose or use the company's secrets. Breaching these obligations can lead to losses and damage to both the individuals and the company's reputation. Trust and clear policies are essential for effective protection. Trade secrets and patents both protect valuable business information, but in different ways. Patents require public disclosure and registration, granting exclusive rights for a limited time. Trade secrets, on the other hand, remain protected as long as they stay secret. This means trade secrets can last indefinitely, but they offer no protection if the information is independently discovered or reverse engineered. Choosing the right form of protection depends on the nature of the information and business strategy. Industrial designs protect the visual appearance of products, such as their shape, pattern, or color. This form of intellectual property is about aesthetics, not function. For example, the unique look of a smartphone or a stylish chair can be registered as an industrial design. This helps businesses stand out in the market and prevents competitors from copying the distinctive appearance of their products. Let's see how industrial designs are registered and enforced. To protect an industrial design, companies must apply for registration with the relevant government office. The application usually includes drawings or photographs of the design and a description of its features. Once registered, the owner has exclusive rights to use and license the design for a set period, often up to 15 or 25 years. Registration makes it easier to enforce rights and take action against imitators. Industrial design protection covers only the visual aspects of a product, not its technical features or function. For example, the shape of a lamp can be protected, but not the way it works. If a design is both new and original, it qualifies for registration. This encourages creativity and innovation in product development, giving businesses an incentive to invest in unique designs. Think about the sleek look of a sports car, the elegant curves of a designer chair, or the distinctive shape of a perfume bottle. These are all examples of industrial designs that can be registered and protected. By securing these rights, companies can prevent others from making, selling, or importing products that copy their unique appearance. This helps maintain brand identity and market position. Exclusive rights granted by industrial design registration last for a limited period, usually between 15 and 25 years, depending on the jurisdiction. After this period, the design enters the public domain and can be freely used by others. This time-limited protection balances the interests of creators and the public, encouraging ongoing innovation and competition. If someone copies a registered industrial design without permission, the owner can take legal action. This may involve seeking damages, injunctions, or orders to stop the infringing activity. Enforcement is easier with a registered design, as the registration certificate serves as proof of ownership. Companies should monitor the market for potential infringements and act quickly to protect their rights. There have been many high-profile cases involving industrial design infringement. For example, disputes over the look of smartphones and fashion items often make headlines. These cases highlight the importance of clear design registration and the challenges of proving infringement. Successful enforcement can result in significant financial compensation and help maintain a company's reputation. While both trade secrets and industrial designs protect valuable business assets, they serve different purposes. Trade secrets cover confidential information that gives a competitive edge, while industrial designs protect the visual appearance of products. The choice depends on the nature of the asset and the company's goals. Sometimes, businesses use both forms of protection for different aspects of the same product. Siding between trade secret and industrial design protection involves considering factors like the type of information, the risk of disclosure, and the importance of visual appeal. For example, a unique manufacturing process might be kept as a trade secret, while the product's look is registered as an industrial design. Consulting with IP professionals can help companies make informed decisions. Trade secrets and industrial designs can be protected internationally, but the rules vary by country. For trade secrets, companies must ensure confidentiality measures are effective in each market. For industrial designs, international treaties like the Hague Agreement make it easier to register designs in multiple countries. Global protection is essential for businesses operating across borders. Protecting trade secrets and industrial designs involves costs, such as security measures, registration fees, and legal expenses. However, the benefits often outweigh the costs, as these forms of IP can generate significant value and competitive advantage. Companies should weigh the investment against the potential returns and risks of not protecting their assets. For trade secrets, ongoing vigilance is necessary to maintain secrecy. This includes regular audits, employee training, and updating security protocols. Even small lapses can lead to leaks and loss of protection. Companies should foster a culture of confidentiality and ensure everyone understands their role in safeguarding secrets. Industrial design protection encourages innovation by rewarding creativity. Companies invest in unique product appearances, knowing they can secure exclusive rights. This drives competition and leads to more attractive, user-friendly products in the market. Protecting designs also supports branding and customer loyalty. One risk for trade secrets is reverse engineering, where competitors analyze a product to discover its secrets. If information can be legally obtained this way, it's no longer protected as a trade secret. Companies must assess the risk and consider alternative protections like patents when appropriate. Accidental or intentional public disclosure can destroy trade secret protection. Once information is widely known, it loses its value as a secret. Companies must educate employees and partners about the risks and implement strict controls on information sharing both online and offline. Industrial design protection also reflects changing trends in consumer preferences. Companies monitor market trends and update their designs to stay relevant. Registering new designs ensures ongoing protection and helps businesses adapt to evolving tastes and technologies. Confidentiality agreements, or NDAs, are essential tools for protecting trade secrets. These legal contracts bind employees, partners, and suppliers to keep information confidential. NDAs set clear expectations and provide a basis for legal action if secrets are disclosed without permission. The process of registering an industrial design typically involves submitting an application with images and descriptions, paying fees, and waiting for examination. If approved, the design is published and the owner receives a certificate. This process varies by country but is essential for securing exclusive rights. Technology plays a growing role in both trade secret protection and industrial design creation. Digital security tools help safeguard confidential information, while design software enables rapid innovation and prototyping. Staying updated with technology is vital for effective IP management. Strong intellectual property strategy combines different forms of protection to maximize value. Companies may use trade secrets for processes, patents for inventions, and industrial designs for product appearance. Regular reviews and updates ensure the strategy remains effective as the business evolves. Many businesses make mistakes in protecting trade secrets and industrial designs. Common errors include failing to document processes, neglecting employee training, or missing registration deadlines. Learning from these mistakes can help companies avoid costly losses and strengthen their IP portfolio. The future of trade secrets and industrial designs will be shaped by new technologies, global competition, and changing laws. Businesses must stay informed and adapt their protection strategies to remain competitive. Embracing innovation and proactive IP management will be key to long-term success. Summary: trade secrets and industrial designs are powerful tools for protecting business assets. Trade secrets safeguard confidential information, while industrial designs protect the visual appeal of products. Both require active management and strategic planning. By understanding and using these forms of IP, companies can enhance their competitiveness and secure their innovations for the future.